Hello and welcome to another edition of On the Road with Legal Talk Network. This is Martin Behn. I'm the chair of the California Young Lawyers Association, CYLA. I'll be your host today's episode, which is being recorded on location at the 2019 Lawyers Association annual meeting in Monterey, California. Joining me today, I have Lydia Lockett and I have Nick Oliver. Welcome to the show, both of you. Welcome, Lydia.
Thank you.
And welcome to the show, Nick.
Hi.
Maybe we can kind of, before we launch into everything, you guys can just kind of introduce yourselves, let us know where you practice and what you do.
Sure. So I guess I'll go first. I'm Lydia Lockett. I practice trust and estates litigation and fiduciary dispute resolution and administration out of Holland and Knight, Los Angeles. And I've been practicing probably going to my 7th year now and just exclusively focus on litigation in the trust and estates realm.
I'm Nick Oliver. I'm an attorney out of Sacramento. I work for the California Energy Commission as a energy and environmental lawyer. I'm also the vice chair of CYLA and will be the chair-elect. So starting after this meeting, I'll be the chair.
Great. So I have both of you guys here today because we're going to basically cover this in two kind of topics. One, Lydia is going to give us some substantive law updates and kind of a little primer. And then we're going to talk about section updates, Nick, and kind of where the next year is going to go. Lydia, you've kind of been an all-star this meeting here this weekend because you have a couple of panels that you're on, and you're also doing a lot of our 10-minute mentor videos for CYLA, so we wanted to thank you for doing that. But I do have kind of some questions about your topic. So one of your topics that you're talking about is basically evidence in the trust and estates and how that's used. So I guess just kind of starting from the beginning, stages of litigation, what can you tell us maybe about things that young lawyers should think about when they're drafting pleading?
Right. And I think that was the focus of our talk was just don't think about your evidence rules just at trial. You need to also think about it at the pleading stage, the discovery stage, and then also at trial. And at the pleading stage, you want to make sure that when you're drafting your pleadings, you're looking at the jury instructions, thinking that it is going to get to trial, what kind of evidence you're going to need in order to sustain your claims through a motion for summary judgment or a motion for summary adjudication, and not to expose your client to malicious prosecution claims if your claims should fail for failure of proof. So if you've got issues with stale, old evidence, hard to authenticate, hard to obtain, think twice about bringing those claims in the first place.
So what's something that could be hard to obtain for you? It sounds like you're saying think about the end of the litigation before you even start the litigation. What are some roadblocks that you've seen before?
Sure, like when you're having your initial consultation with your client and they're telling you about the facts of their case and they're talking about transactions that might have happened 20 years ago, even 15 years ago, and they don't have bank records or any sort of documentation to show that the transactions that they're concerned about happened. If you're going to try to subpoena those records from a bank, for instance, we've got document retention policies about 7 years. You're going to have a really hard issue of proof, trying to prove that those transactions actually occurred the way that you're going to allege them. So those are one of the typical issues that you might want to keep an eye out for.
Interesting. Mm-hmm. And then let's just say we've filed our pleadings. What should the young attorneys or what should we be doing in the discovery phase of litigation?
So when you're thinking about discovery, think about it in terms of if you don't have it, you can't use it at trial. If your opponent does not have it, they can't use it at trial either. So the key is to be very strategic with your objections, know your discovery rules, know what your burden is in order to justify the discovery you're seeking, and know what the burden is if you're going to be asking to resist discovery through objecting. And you have to really be very careful about looking at the specific code of civil procedure sections that relate to the discovery that you're dealing with, because the burdens differ. One big difference is there's a good cause requirement for document productions in order to get that information, whereas with requests for admissions, interrogatories, and even just oral depositions, there's not necessarily a good cause requirement for those. So really keep track of those, keep track of special objections, privilege. Those can be very tricky, they can be very nuanced, and because they are, you can use them very strategically to block the discovery of information that you don't want to have discovered, or you can use them you can know the nuances of them to make sure that you are able to get the things that you are wanting to discover.
I'm going to throw you a curveball here. Is there anything different about what your practice is in the probate court versus maybe the civil court in the discovery phase?
There are certain very probate-specific trust and estates carve-outs, especially with respect to privilege. And that's one of those key distinctions that if you're practicing in civil and you're coming over to probate, you might not be aware of those trust and estate-specific carve-outs for privilege, for instance. Patient-physician is one of them. We all know that there's a privilege between patients and physicians. There's a carve-out that is relative to trust and estates, where if the communication between the doctor and the patient is relevant to an issue that relates to all parties who are in a dispute regarding something that they're going to get from a deceased patient. So I'm talking about if the issue is like capacity or their physical well-being, that might actually have an impact that you wouldn't see necessarily in non-probate litigation.
That's interesting. So kind of moving on, let's say you've done the pleading and the discovery, and what are some special objections that might occur in your practice versus maybe something else?
So you're talking about you're a discovery still?
your discovery maybe.
Okay. So attorney-client privilege is also another one of those big special objections that you see a lot in trust and estates context, because there are rules governing successor fiduciaries and who holds the privilege when you've got a client who is now deceased. Typically in trust and estates, you got to have a personal representative to assert or waive the privilege. And then also in trust and estates, you often find attorneys representing multiple people, multiple beneficiaries, multiple fiduciaries, and that joint rep situation is kind of a tricky one, because as between joint clients, the joint clients can't really assert the privilege against each other, even with trilateral or bilateral communication. So, and there's also attorney work product issues. I could go on and on with respect to estate planning files, whether or not they can be disclosed or discovered, because they aren't being prepared for litigation or trial necessarily. And that's what we typically think of with respect to attorney work product, especially since there's a federal rule that specifically says the work product needs to be produced for the purposes of trial. So those are just a couple.
Interesting. The kind of last substantive question I had, let's say you have the evidence at trial. Are there certain types of exclusions, even though you've discovered a whole bunch of information? Is there certain stuff that doesn't ever come in or can be barred? Or?
Sure. I mean, like one of the big things that I've seen, at least in my experience with trial, is you got to be very, very careful about what you do in discovery, because that can have an impact at what comes in trial. So, for instance, we had a case recently, or a couple of years ago actually, where opposing counsel, exchanged exhibit lists with us, and we saw a bunch of documents that they hadn't produced during discovery, but which were responsive to our requests. We filed a motion to eliminate it, exclude it, because it was not fair for them to try to bring that in at trial when we had not seen it before. And also, they'd missed the discovery cutoff, so they never actually got a chance to depose our clients before trial, which was a huge problem for them. So, I mean, complying with discovery rules and being careful and cognizant of them is very, very important and can have a huge, huge impact on your success at trial.
That's great. Anything we didn't cover that you might want to tell us about some of your presentation? Or
I think I've covered most of the high points. That there was a lot of information in there, so I'm keeping it high level at this point.
We only have 10 minutes for a whole hour-long presentation.
Exactly.
Cram it in there. Well, thanks so much. So next we're going to kind of move on to the CYLA section updates and kind of upcoming programs. So, this last year was my year to chair the section, and it's been a year of transition for CYLA and the CLA, the California Lawyers Association, as a whole. Something that we've really kind of pushed to do is do networking events. So we had a successful one down in LA. We had some up in Northern California as well. We've been putting on substantive webinars throughout the year, and we've also had a lot of our CYLA board members partake in being on part of a lot of substantive law updates. I know, Lydia, you've been doing quite a few this last year for the Trust and Estate section, so I'm sure they're very appreciative of that. But something else we're kind of doing, in even today at the annual meeting, we're doing a lot of 10-minute mentor videos that we hope to get up online. Just kind of quick snippets of things that have occurred today at the annual, or this weekend at the annual meeting, and kind of provide some value to our value to our constituencies. CYLA is growing. It's an exciting organization to be a part of because with our new format, each of the 16 sections of the California Bar, or of the CLA, sorry, I'm still a holdover from when the CLA was part of the California Bar. Each of them have a section liaison on our board, and we end up integrating them into our board, and we're very happy to be able to work with the various sections in order to not only promote the sections, but also promote good substantive legal work and information for our constituents. But I'm going to kind of go over to Nick. Nick is going to be our incoming chair for 2019 and 2020. Nick, what do you see your next year as chair like? Are there any initiatives you'd like to start or anything you'd like to continue or highlight?
Yeah, well, I think this is maybe where I sort of end with the beginning and remind the listeners, some of whom may be CYLA members, but some who may not be, that we, by definition, California lawyers in their first 8 years of practice are automatically enrolled as members of CYLA upon admission to the bar. So that's really who our demographic is, who we serve, and who our executive committee is made up of as well. Martin mentioned the composition of our board is being primarily composed of the section liaison representatives from the 16 CLA sections. And so the way I see at a high level our growth heading and what I see my goals as chair in the coming year would be to capitalize on this new integration of CYLA and the sections and build on our existing collaboration and help foster maybe weaker points or, basically make every section's connection to CYLA much stronger than it has been in the past. And so by bridging those connections with the sections, I think that we will grow CYLA, and meet the needs of a broad, diverse group of our membership, which currently, we reach through our emails upwards of 50,000 members in California. So there's a huge base of CYLA members, some of whom are actively involved and some of whom may not be as involved. But I think by increasing collaboration with the sections, fostering growth in social media and other channels, we'll really capitalize on our new structure of this board. Anything else you want to kind of add about the upcoming year for CYLA? The only thing I would add on to that point is I really see there has been kind of 7 different approaches to collaboration with CYLA that I've talked about in other capacities, but you touched on a few of them. We're obviously building our 10-minute mentor program, and we're continuing to produce webinars monthly. But we also have our quarterly e-news. We have a catalog of self-study articles. We're building mentorship programs. For example, for the first time ever, CYLA and the environmental law section are having a mentor pairing program at their Yosemite meeting next week. And then obviously we continue to provide many discounts to CYLA members on programming provided by the other sections, and we're proud to continue offering those opportunities. Great. Well, it looks like we've reached the end of our road for our episode today. I want to thank Lydia.
You're welcome. Thank you for having me.
And thank you, Nick, for joining us today. If our listeners have any questions or wish to follow up, how can they reach you to?
They can email me at Lydia, Lydia, .Lockett, Lockett, at hklaw.com.
And for me, I would encourage you to reach out to CYLA at calawyers.org. That's the general CYLA email, and we can always be reached that way. Also, thank you to our listeners for tuning in. If you like what you heard, please rate us and review us in Apple Podcasts, Google Podcasts, Spotify, or your favorite podcasting app. I'm Martin Behn. Until next time, thank you for listening.
If you'd like more information about what you've heard today, please visit LegalTalkNetwork.com. Subscribe via iTunes and RSS. Find us on Twitter and Facebook, or download our free Legal Talk Network app in Google Play and iTunes. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by, Legal Talk Network, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer.